Oh,
You just stop it. You just-
Senate will please come to order. Today we'll have another moment of silence as we gather for a slew of bills. Thank you. I have to say, when we're in this building all day and there are so few moments of silence, I find it kind of nice to have half a second. And I'm not in committees all day as you are, so. Are there any announcements? Senator from Chittenden Central.
Thank you, Mr. President. I just wanted to tell the body that I just attended the ceremony of the swearing in for our new Chief of Police here at the Capitol, John G. Polway, now sworn in as our Chief of Police, and he is a fantastic pick. If you haven't met him yet, I'm sure you will agree. We also promoted 2 of our Capitol Police officers to sergeant. So the Capitol force is in a rebuild mode, and I think it's looking very strong these days. So just to keep the body abreast. Thank you, Mr. President.
Are there any further announcements? Seeing none, we have a handful of House bills for reference. First being H 121, a fairly robust bill. It passed the House on March 22nd. Please listen to the first reading of the bill.
H 121, an act relating to enhancing consumer privacy.
Now you've heard the first reading of the bill is referred to Committee on Economic Development, Housing and General Affairs. We have H 639, which passed the House on March 22nd. Please listen to the first reading of the bill.
H 639, an act relating to flood risk disclosure, accessibility standards for state-funded residential construction, housing accountability, and recovery residence evictions.
Now you've heard the first reading of the bill is also referred to the Committee on Economic Development, Housing and General Affairs. We have H 706, which passed the House on March 22nd. Please listen to the first reading of the bill.
H 706, an act relating to banning the use of neonicotinoid pesticides.
Now you've heard the first reading of the bill is referred to the Committee on Agriculture. We have H 845, which passed the House on March 20th, excuse me, 21st, no less. In fact, the 22nd, as I read farther down the list. Please listen to the first reading of the bill.
H 845, an act relating to designating November as Vermont Month of the Veteran.
Now you've heard the first reading of the bill is referred to the Committee on Government Operations. And H 878, which passed the House on March 22nd. Please listen to the first reading of the bill.
H 878, an act relating to miscellaneous judiciary procedures.
Now you've heard the first reading of the bill is referred to the Committee on Judiciary. That brings us to the orders of the day. The first item on our calendar is we're going to do third readings. Been requested we do third readings first. So the third item on your calendar is S 192. And S 192 has had third reading ordered. It is an act relating to forensic facility admissions criteria and processes. I believe there is an amendment in the calendar, so I'd like to recognize Senator from Bennington.
Thank you, Mr. President. I'd like to leave the Senate to withdraw the amendment. It stirred some questions from various groups, and I think it may be dealt with in the other body.
Without objection, the senator's amendment will not be offered. Are there any amendments to be offered before third reading? Seeing none, please listen to the third reading of the bill.
S 192, an act relating to forensic facility admissions criteria and processes.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have passed S 192. We now have up for consideration S 98. S 98 is an act relating to Green Mountain Care Board authority over prescription drug costs. Are there any amendments before third reading? Seeing none, please list. The Senator from Chittenden Southeast asked for a roll call. When the time comes, for the moment, we'll have third reading of the bill.
S98, an act relating to Green Mountain Care Board authority over prescription drug costs.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for the question? If so, the secretary shall commence to call the roll.
Senator Baruch,
Yes.
Senator Bray,
Yes.
Senator Brock,
Yes.
Senator Campion,
Yes.
Senator Chittenden.
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
Yes.
Senator Bueller,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim, Senator Engel,
No.
Senator Kitchell,
Yes.
Senator Lyons,
Yes.
Senator McDonald,
Yes.
Senator Mazza, Senator McCormick,
Yes.
Senator Norris,
No.
Senator Pershing,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears,
Yes.
Senator Starr,
Yes.
Senator Yosti,
Yes.
Senator Watson,
Yes.
Senator Weeks,
No.
Senator Westman,
Yes.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner,
Yes.
Senator Hashim, Senator Mazza,
Please listen to the results of your vote. Those voting yea, 23, those voting nay, 5, and you have passed S98. We now have up for consideration S114. S114 is an act relating to removal of criminal penalties for possessing, dispensing, or selling psilocybin and establishment of the Psychedelic Therapy Advisory Working Group. Are there any amendments for third reading? Seeing none, please listen to the third reading of the bill.
S114, an act relating to removal of criminal penalties for possessing, dispensing, or selling psilocybin and establishment of the Psychedelic Therapy Advisory Working Group.
Now you've heard the third reading of the bill, and the question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have passed S114. We now have up for consideration S120. S120 is an act relating to post-secondary schools and sexual misconduct protections. Are there any amendments to be offered before third reading? Seeing none, please listen to the third reading of the bill.
S120, an act relating to post-secondary schools and sexual misconduct protections.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed S120. We now have up for consideration S204. S204 is an act relating to reading, assessment, and intervention. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S204, an act relating to reading, assessment, and intervention.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Senator from Chittenden Central.
Thank you very much, Mr. President. May I speak to the witnesses that we had in our committee?
You can speak to anything you want with respect to S204.
Fantastic. I was so excited yesterday that I neglected to mention some of the incredibly important witnesses that we had in our committee. I'm not going to name all of them because they're 2 pages worth, but they were incredibly helpful in drafting this legislation and in teaching us about reading and literacy, frankly. We had Gwen Carmoli from the Vermont Curriculum Leaders Association, Sue Siglowski from the Vermont School Boards Association, Jess DeCarolis, who's the Division Director of Student Pathways at the Agency of Ed, Doreen Dorfman, who is a member of the New Hampshire International Dyslexia Association, Cynthia Gardner Morse, who's a literacy tutor from Calais or Calais, as we say it in Vermont. Kristen Wells Wynn, who is the State Literacy Director, Office of Elementary Ed and Reading at the Mississippi Department of Education. My friend Steph Waite, who is a former teacher at the Stern Center and is now a private literacy coach. And Nora Briggs, who is the Executive Director of the North America Dollywood Foundation. Thank you very much.
Question is, shall the bill pass? Are you ready for the question? Senator from Essex.
Thank you, Mr. President. Can I interrogate the reporter of the bill?
The senator from Chittenden Central is interrogated as a reporter of the bill.
Thank you, Mr. President. I was just wondering if this is going to put any undue burdens on our independent schools or our home schools, Mr. President.
That is a fantastic question. And my answer to that would be that we had advocates and administrators from the independent school world come into our committee, and we actually compromised on some language that they found favorable. So I am not concerned about that. This bill didn't really touch homeschooling, so that is not really an issue.
Mr. President, why wouldn't it touch homeschooling? I mean, we're trying to get to literacy, and it seems like they would have the same set of standards as what all the other schools would have. So could the presenter elaborate just a little bit more about the homeschool portion of it?
So that's a great question. Homeschooling, obviously, when you are in a homeschool program, your parents are, or your caregivers are your educators. I would imagine that unless they were to ask for it from their either independent school or their public school for the screening, they would have to do the screening on their own. But that's a great question and maybe something that we could consider in the future.
I thank the presenter. Thank you, Mr. President.
Question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have passed S204. We now have up for consideration S220. S220 is an act relating to Vermont's public libraries. There is an amendment in the calendar, so if the proposer amendment would care to offer it, now would be the time. Senator from Chittenden North.
Thank you, Mr. President. If you would turn with me, please, to 1664 and today's calendar, you will see the one word change that I offered to check about yesterday. That would be specifically changing the word less to fewer in the phrase, the board shall not consist of less than 5 members.
Senator from Bennington.
Thank you, Mr. President. Your Senate Education Committee met with Senator Renner yesterday afternoon and found this amendment favorable on a vote of 5-0-0.
Question is, shall the bill be amended as offered by the senator from Chittenden North? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it, and you have amended the bill as offered by the senator from Chittenden North. I will point out that the senator from Bennington I almost heard him ask for a roll call, but thankfully it didn't quite reach my ears. Are there any other amendments before third reading? Seeing none, please listen to the third reading of the bill.
S220, an act relating to Vermont's public libraries.
Now you've heard the third reading of the bill. The question is, shall the bill?
Please.
Roll call has been requested by the senator from Addison. Question is, shall the bill pass? Are you ready for the question? If so, the secretary shall commence to call the roll.
Senator Baruch,
Yes.
Senator Bray.
Yes.
Senator Brock,
No.
Senator Campion,
Yes.
Senator Chittenden.
Yes.
Senator Clarkson,
Yes.
Senator Collingwood,
No.
Senator Cummings,
Yes.
Senator Bewley,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim,
Yes.
Senator Ingle.
No.
Senator Kitchell,
Yes.
Senator Lyon,
Yes.
Senator McDonald,
Yes.
Senator Mazza, Senator McCormack,
Yes.
Senator Norris,
No.
Senator Pershing,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears,
Yes.
Senator Starr,
Yes.
Senator Zibowski,
Yes.
Senator Watson,
Yes.
Senator Weeks,
No.
Senator Westman,
Yes.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner,
Yes.
Senator Mazza,
Please listen to the results of your vote. Those voting yea, 23, those voting nay, 6, and you have passed S 220. We now have up for consideration S 254. S 254 is an act relating to including rechargeable batteries and battery-containing products under the State Battery Stewardship Program. Third reading's been ordered. I do see there's an amendment in the calendar if the Senator from Addison cares to offer that. Senator from Addison.
Mr. President, there is, as said, there's an amendment to S 254 that appears in our calendars beginning on page 1665. Probably all of us have had the unfortunate experience of using a computer and having some sort of glitch that meant we had something didn't work the way we thought. In the drafting of 254, there was a glitch that caused a section to drop out of the bill prior to voting it out of committee. We wanted to reinstate that section, and it is here as the first instance of amendment. It's a right of private action. You might wonder why such a thing exists. At the outset of the creation of the stewardship program on batteries, there were more than one organization receiving batteries back and handling them in the EPR program. And they wanted to have an opportunity if they were receiving, if there were batteries companies that were freeloading on the system, to be able to recover their costs from those who weren't participating. You can see the trigger for using the right of action, and that appears on 1666, subsection D, condition precedent to cause of action. So it's only allowed in order to accomplish reimbursement for services rendered by a stewardship organization to a battery manufacturer who hasn't participated in that stewardship organization. So it's a way of settling up accounts. The second instance of amendment appears on page 1667, and this just makes the adjustment to insert that section and number appropriately thereafter. Committee reviewed the proposed amendment, which I'm offering on behalf of the committee, and our committee vote was 5-0.
Question is, shall the bill be amended as offered by the senator from Addison? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it. You've amended the bill as offered by the senator from Addison. Are there any other amendments before third reading? Seeing none, please listen to the third reading of the bill.
S 254, an act relating to including rechargeable batteries and battery-containing products under the State Battery Stewardship Program.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? Senator from Franklin.
Mr. President, may I inquire of the reporter of the bill?
The senator from Washington is interrogated as the reporter of the bill.
Yesterday, when we discussed the bill in second reading, there was a question raised as to whether or not this would have any cost. And I believe I understood the answer by saying that there wouldn't be any cost because it would be something that would be covered by the manufacturers regardless. And the more I thought about that question, I thought, well, somebody's got to, well, one, we're creating a new stewardship organization under this bill. Somebody's got to go out and retrieve the batteries and spend the gas to do that with something new, and then handle and manage and ship and move those batteries throughout the state. And we're talking about lots of little batteries over a period of time. Somebody's got to store those batteries somewhere while it's being done. And so my question is twofold. Are you sure that there's no cost anywhere, that anybody's going to pay for this, one, or that the manufacturers and people who do the storage are going to do this and expect to do it for free? Is that the anticipation?
Thank you, Mr. President. I would just clarify that it is not, first of all, it is not creating a new program, it is extending a current program, an existing program. Second thing, though, I guess I would, I want to make sure that I'm understanding your question. So do you mean, is there no cost that we anticipate being added to the price of batteries to consumers? Is that your question?
Well, anywhere along this particular chain, and of course, I am most interested in cost to consumers because it's obvious that the actual accomplishment of this work isn't going to be free. And so I'm just wondering who's the benefactor?
Thank you. Thank you for that clarification. So certainly there are costs along the way in terms of storage and transportation. And as I even mentioned, the cost that's associated with the fires when things are not handled properly. So that cost right now is being borne by the solid waste management facilities mostly. And so this bill will create better compensation for those collection sites. And so the answer that I gave previously was in regards to specifically, is there likely to be an increase in costs to the price of batteries that consumers see? And the answer was no, based on the data that we have from those who are participating in the voluntary program, where we have not seen any increase in the consumer price of those batteries. And because the markets that we're talking about, the manufacturers are international and national in scale. And so this is an instance where the fact that Vermont is a relatively small market actually plays to our advantage because it is not worth their while to increase the costs just for the state of Vermont.
Thank you, Mr. President. Did the committee receive any testimony from battery manufacturers that this would be free?
That the cost to consumers would be free?
Yes.
The answer that we got was to that regard was from one of the solid waste management districts, who is a part of a steward, it's a solid waste management district, but I believe she had another role that was involved in the stewardship organization.
Does she price batteries for the manufacturers?
I'm merely telling you what she reported.
So then we didn't get any direct information from any manufacturer of batteries that none of these costs would be passed on?
I'm not sure. We did hear from, actually, let me just check my list here quickly about who we did hear from. I am not seeing my, oh wait, yes, I do. We did hear from the Product Stewardship Institute on this, as well as the Rechargeable Battery Association. And so the Rechargeable Battery Association would be composed of battery manufacturers.
And they said that there would be no charges passed on to the consumer.
They did not make any comments to that effect, but we did hear from them and heard their comments.
I'm sorry?
We did hear from them generally.
But they made no comment about whether the cost would be passed on.
That's correct.
Okay, I thank the reporter.
Thank you.
Yeah. I'm concerned when we pass things that create costs somewhere in the value chain that goes to consumers. I have found very few beneficent manufacturers who sell things to Vermonters. And when there's a cost somewhere along the line, that manufacturer who owes their duty to their shareholders has to recover the costs that they spend. And it may be that the cost here in Vermont are going to be small relative to the nation as a whole, but they are additive. And when Vermont, quote, leads the way, unquote, as we have this habit of doing, and somebody else follows, somebody's got to recover the cost from somewhere. This ultimately will be money that has to be recovered. And as I say, manufacturers are not in the business of being charitable organizations, and we're going to pay for it. We're going to pay for it. And that's why I'll be voting no on this bill, at least at this point in time. Thank you, Mr. President.
Senator from Madison.
Thank you, Mr. President. I think the questions from the senator from Franklin, we are familiar with the whole notion. There is no such thing as a free lunch, but there is already a battery program, and we have experience with it for a decade, and it's showing us that the manufacturers have not been, in fact, passing any price increase along to consumers. And the reason, as the reporter said, is because the Vermont market is so small that it is not worth their while, apparently, in their judgment, to try to price differentially, track batteries into the state, et cetera, in order to exact such a fee. I also want to point out another cost, and which the reporter also highlighted, which was solid waste material handling facilities have experienced on a regular basis fires, small or large. There was hundreds of thousands of dollars of damage to a MRF when a battery burst into flame, started a fire in the night and burned down a substantial portion of the facility. So we're seeing costs on both sides, and judged it a responsible thing to move forward.
Question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have passed S-254. We now have up for consideration H-554, an act relating to the approval of the adoption of the charter of the town of South Hero. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
H-554, an act relating to approval of the adoption of the charter of the town of South Hero.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed H-554. We'll now return to the top of the calendar where we have S-285. S-285 was read the first time and referred to the Committee on Judiciary, which considered the same and recommends that when amended, the bill ought to pass. Please listen to the second reading of the bill.
S-285, an act relating to law enforcement interrogation policies.
Now you've heard the second reading of the bill. For the report of the committee, the senator from Chittenden Central.
Thank you, Mr. President. As I present S-285, you may experience some deja vu. I did know that I did while writing this report. S-285 is part of a bill that this body has already passed. Last year, we passed S-6, which was a ban on the use of deceptive interrogation practices for people under the age of 22. It also tasked the Vermont Criminal Justice Council to develop a model interrogation policy for all people that relied on evidence, best practice, and moved away from the internationally debunked practices like the Reed method and other abusive and deceptive practices. This bill does not ban the practice of deceptive interrogation practices for anyone, as we heard from people that they need new tools before the ones they've relied on are banned. What S-285 does do is take the model policy language from S-6 and change it slightly to ask the Law Enforcement Advisory Board and the Vermont Criminal Justice Council to establish a model statewide policy for interrogations of all persons in custody that is in line with international evidence-based best practice and will be implemented by all departments by April 1st, 2025. Section 1 of the bill is the legislative intent section, which has multiple intents, including building trust between the police and their communities, utilizing evidence-based best practice for interrogation, preventing false confessions and wrongful convictions, and eliminating the use of threatening or deceptive interrogation practices. Section 2 of the bill asks the LEAB, the Law Enforcement Advisory Board, to consult with the Attorney General to establish a model interrogation policy by October 1st of 2024. By December 1st of 2024, they will present their model policy to the Joint Justice Oversight Committee for review, and on or before January 1st, 2025, the Vermont Criminal Justice Council shall, in consultation with the Agency of Human Services, the Vermont League of Cities and Towns, and the Vermont Human Rights Commission, update that policy so that it is a cohesive policy for all law enforcement to follow. In Section 3, all law enforcement agencies are required to adopt at minimum the model policy. They may go above and beyond in protecting people from deceptive interrogation practices, but at minimum, they must adopt the model policy, or they will no longer be eligible to receive state grants. This policy of money being linked to compliance with policy requirements has been established before to enforce other model policies, like the use of force policy that was established in 2022. Section 4 is a definition section and directs the Criminal Justice Council to establish this model statewide interrogation policy that be adopted by all law enforcement agencies. This section also asks the Criminal Justice Council to review and update the model policy in accordance with best practices by October 1st of 2025 and every odd number year thereafter. The Criminal Justice Council and the Attorney General are also tasked to review the local law enforcement agencies' interrogation policies to ensure compliance with the statewide model policy. And if they find that an individual law enforcement agent's policy does not meet the requirements of the model policy, they shall work with that agency to bring the policy into compliance. The model policy shall become part of training and certification. Annually, on or before July 1st, the Criminal Justice Council shall report to the House and Senate Committees on Judiciary regarding what law enforcement agencies and officers have received training on these model interrogation methods. Section 5 is the effective dates. The act shall take effect on July 1st, 2024, except Section 3. This is the section that makes grant eligibility contingent on adoption of the model policy. We would not want to make anyone's grants contingent on a policy that does not yet exist. So this section takes effect on April 1st of 2025. At a time when there is rampant lack of trust between our communities and law enforcement, they should at the very least know that they will not be threatened or lied to during custodial interrogation. The Innocence Project found that 36% of those who have been exonerated on DNA had falsely confessed under deceptive interrogation practices. Of the 397 DNA exonerated individuals in this Innocence Project cohort, 96 or 24% were under 18. 155 or 39% were between 18 and 25, and 146 or 37% were over the age of 25. To say that this is only a problem for children is simply not true and does not follow the data. This policy asks the Law Enforcement Advisory Board to create a policy that protects Vermonters, relies on the data before us, and utilizes international best practice before any prohibition is considered. This practice and the method have been prohibited in the United Kingdom for over 4 decades, in all of Europe for more than 2 decades, and more recently in Australia and New Zealand. The United Kingdom led efforts to improve interrogation techniques, and in 1992, a new interviewing model was developed, informed by academic research showing a correlation between coercive and deceptive techniques and false confessions. This model is known as the PEACE method. The International Association of Chiefs of Police have come out against the practice of deceptive and threatening interrogation practices and encourage training methods that are effective, evidence-based interrogation practices like the PEACE method. New Zealand has strongly rejected the deceptive interrogation practices and instead now uses the PEACE model as well. It shows notable improvement in investigative interviewing and instances of false confessions. Further, in 2016, the United Nations General Assembly encouraged worldwide adoption of the United Kingdom's PEACE method as best practice for investigative interrogations. The PEACE method does not rely on abusive practices, does not have the same rate of false confessions or false recantments, as these deceptive practices have also been used to coerce sexual assault survivors into taking back their reports of sexual assault. This will help us move towards a more trusting relationship between our communities and law enforcement and make our communities safer for all Vermonters. As a state, we should strive to ensure that any confession is accurate, freely given and obtained without interrogation techniques that are not based in modern science. It's time for us to take a step forward in joining other countries in how we interrogate suspects and victims. Just because we have always done something a certain way does not mean it's the right way to continue. We now have better information and better options available to us. 7 other states are currently moving forward with some form of ban on the use of deceptive and coercive practices. And I believe that in Vermont, our criminal legal system should rest on fairness and justice. And this includes ensuring Vermonters know that they will not be lied to in a custodial interrogation. The Judiciary Committee has spent the entire biennium in finding a path forward for this policy that is measured and takes into account all stakeholders, while also working towards building trust and integrity in our law enforcement system. The Judiciary Committee voted 3-0 and asked for the Senate to concur. Thank you.
I've heard the report of the Senate Committee on Judiciary, and the question is, shall the Senate adopt the report of the Committee of Judiciary? I do see an amendment in the calendar. If the senator is interested in offering it, now would be the time.
Oh.
Senator from Franklin.
There is an amendment, I believe, on the calendar today to S-285. I believe there is also a handout of just some additional background information about the amendment and about the bill itself that is being passed out. I believe that you may have received some of this by email yesterday. The particular amendment is a strike all, and strike all, I believe that you should look at. Let me go over quickly the differences between what's in the strikeout and what's in the underlying bill. The first piece of the strikeout goes to the legislative intent in which we've struck from the interrogation policies intent to progress towards a total prohibition on the use of deception in all forms of interrogation. And I'll come back to that as to why and what this actually means. It drops the prohibition of law enforcement's use of threats, physical harm, and deception during interrogation of all persons consistent with addressing the use of deception during custodial interviews of juveniles. And I'll come back to that because it doesn't mean quite what it looks to on the surface, because it's addressed later in the amendment. With respect to the Section 2, the Criminal Justice Council model interrogation policy, instead of covering all persons as the underlying bill does, the amendment covers juveniles. Going on to page 2 of the amendment, it also eliminates the provision regarding custodial interrogations occurring in a place of detention, custodial interrogations occurring outside a place of detention, and interrogations that are not considered custodial locations. It deletes the issue of interrogations with certain kinds of people with disabilities, and the model policy will prohibit the use of physical form, harm, threats, or deception. That is deleted also, but again, parts of this are put back in later on. If we go to page 3 of the amendment, these are where some of these items are put back in, but in somewhat different form. It requires the Law Enforcement Advisory Board to submit a model interrogation policy to the Joint Legislative Justice Oversight Committee and testify before the committee, much as it does in the underlying bill. Council, in consultation with stakeholders, including the Agency of Human Services, the Vermont League of Cities and Towns, and the Human Rights Coalition, shall update the law enforcement model interrogation policy to establish one cohesive model for law enforcement to use. As we move to page 5 of the proposal, which you may have in somewhat different, but I'm looking at section 4, item subsection A, correction, subsection B1. Again, it applies to juveniles as opposed to all persons in various forms of custodial interrogation. Subparagraph A following that defines deception as the knowing communication of false facts about evidence or unauthorized statements regarding leniency by a law enforcement officer to a subject of a custodial interrogation. And right now, the the issue of deception is defined in very much the same way about false facts. It adds here that the model interrogation policy shall address the use of deception during custodial interviews of juveniles. But it strikes out the issue of interrogation that are not considered custodial regardless of location. In the underlying bill, you'll notice that it referred to interrogations wherever located. It first described custodial interrogations. It then described interrogations that are not custodial. Custodial interrogations are defined by statute in Vermont. And they have to meet a couple of specific standards. Custodial interrogation has to be any interrogation involving questioning by a law enforcement officer that is reasonably likely to elicit an incriminating response from the subject. And also where a reasonable person in the subject's position would consider the person to be in custody, starting from the moment a person should have been advised of the person's Miranda rights and ending when the questioning is concluded. The underlying bill goes far beyond that. It refers to interrogations generally without a definition elsewhere in statute. It's called questioning. We know what an interrogation is. And I'm concerned that it goes too far. It goes too far because witness this interrogation. An undercover narcotics officer approaches a person and says, "Will you sell me cocaine?" And before answering, the person says, "Are you a cop?" And the officer responds, "No." Isn't that deception within the meaning of deception as it's contained in the underlying bill? He's lied to him. And that applies whether it's a custodial situation in which the person is A, in custody, or B, should have been advised of his Miranda rights. That's not true in an undercover drug buy situation. It would appear, and again, someone could argue this in terms of legislative intent, but that's what it says. And I don't think that's what we mean. Again, as you look further on in the amendment, it's clear the amendment applies to juveniles, which is what is intended. And the reason that's intended is because when we look at the history of false confessions, we talk about false confessions. When do they occur? And I really question quite a number of the quote academic researchers who applied this, because when you look at these and you look at them on an item by item and issue by issue basis, classic example is Central Park 5. Remember that case? That's the case in which 5 Black teenagers in New York City were accused of raping a victim in Central Park. 4 of the 5 confessed. They were convicted. They went to jail for up to 12 years. Then they were exonerated when a serial rapist was arrested, DNA compared, and found to be the person who committed the crime. Question, of course, again, in the false confession theories is this was a false confession. It was. But what often the academics don't go into when they describe the situation more thoroughly, the individuals who confessed were threatened. In some cases, they were physically beaten. In other cases, and in fact, in all cases, there was an exceptionally long period of interrogation. They were denied specific rights that they have in Vermont already. And time again, when you read these false confession statements, and in fact, it's contained in the underlying bill, it doesn't say just confessions. It says confessions and it's the and that's the problem. The bill goes on to prohibit, for example, the use of the Reed method of interview and interrogation, saying that that has been a discredited method. Well, I got to tell you, the Reed method is used here in Vermont, has been for years. The Reed method, the state police, some members of the state police use it, although they have moved for training purposes to the Peace method. Peace method is used in the UK. And why did we change? Why is the UK so much different than the US? Well, for one thing, because they don't have the Miranda requirement that we do have in the US, or to the extent that we have it, it's different. It's a different standard. I'm very familiar with the Reed method of interview and interrogation. I was first trained in it. I hate to say how old I am. but I had my first Reed training course in 1972. And I've had a number since then. And the one thing that you have to know about the Reed method of interview and interrogation, and it is interview and interrogation, it isn't just interrogation, but what precedes it. And in everything in the Reed training, when it talks about the core principles of it, it's based on some core principles that I might read to you, if I may, Mr. President.
Without objection, you may.
Always conduct interviews and interrogations in accordance with the guidelines established by the courts. Do not make any promises of leniency. Do not threaten the subject with any physical harm or inevitable consequences. Do not deny the subject any of their rights. Do not deny the subject an opportunity to satisfy their physical needs. And above all, it goes on to say, do not conduct excessively long interrogations, period. That interview is done before any accusatory interrogation begins. It's a fact-gathering exercise. Why would you conceivably lie to someone in an interrogation? Well, it's a method, A, of obtaining information. It's a method of testing whether the information that you get is true. Before, under the Reed method, you accept a confession that is rendered to a person, you have to, A, get corroborating evidence, one, and two, typically in interrogation, you ask questions about the physical scene or about the incident that you're investigating that the subject doesn't know the answer to. For example, only the perpetrator, if he's not a police officer, knows that the victim was wearing a purple polka dot dress, unless somebody has told him that. And so you're looking for that information to corroborate that the person's confession is in fact valid. And there are a number of other tests that you typically use in interrogation to do that. Is it a valid investigative technique? Well, yesterday we passed a bill S-120 that was specifically focused on helping resolve the wave of sexual abuse and sexual violence claims that occur in colleges and universities. That technique is a technique that is used to resolve such cases. It's a technique that police aren't just pulling out of the corner someplace that nobody knows about. The use of deception of that kind in an interrogation has been approved by the Supreme Court. It's been approved by 3 federal appeals courts. And as late as 2018, it has been approved by the Supreme Court of the state of Vermont as valid. In that particular case, which is a very interesting case, given what we've been looking at, it's the case of State of Vermont versus Koltz, K-O-L-T-S. In this particular case, Koltz was convicted by a jury of aggravated sexual assault of a child. Part of the evidence, not all the evidence, part of the evidence against Koltz was a confession that he gave to a Middlebury detective. That Middlebury detective used deception in her interview of the subject. The deception, as I recall, was something to the effect of there was a rape kit, some sort of physical evidence that was done that showed that you were the perpetrator. How do you respond to that? At which the person subsequently believed that he was caught and confessed. But it was not solely on that deception because there had been no such test form. That's a very common in sexual assault claims, a way of interviewing a person who has done that sort of thing. I've done it myself. And the usual response that you get to a person who's done it, who's denied all activity, and who in fact is the perpetrator, is he often then says, well, yes, I did have sex with her, but it was consensual. Heard that over and over again. That's had many interrogators. But it's a step. It is not conclusive that this person is going to be convicted or that that is the only evidence that's going to be presented, because it has to be corroborated. You need independent evidence. And there are other reasons for deception also as control questions, but I won't even get to that. But the courts have over and over, including recently, approved this as a method that's valid, provided And again, this is the big provided here. And when we see these false confessions that are reported in other states, time and time again, they violated those principles of interrogation that I mentioned that have to be used at the same time. Do it in accordance with guidelines established by the courts. Do not make promises of leniency. Do not threaten the subject with any physical harm. Do not deny the subject any of his or her rights. Do not subject them to fail to satisfy their personal needs. And don't hit them. And then also do enough post-interrogation to determine whether or not the information that you've obtained during the interrogation, which is not simply a yes or no, whether or not it comports with other evidence that you have, other material that you can support, and in particular, have you conducted the interrogation in such a way that the individual can answer a question known only to the police, the results only to the police, and not to the general public, and not to the person being interviewed. Those are the tests. What this amendment does is it reinstates the issue of using this kind of technique, even targeted deception is what it's called, in interviews of adults, eliminates it for interviews of juveniles, and it also eliminates it for people who have obvious mental or other defects that are obvious to the interrogator, so that those not used in those circumstances. Such interrogations, when done in a custodial sense, also have to be, by law that exists right now, that our custodial interrogations have to be recorded electrically, so that you know what was said and how it was said. And desirably in an audio-visual format so you can see that there was no abuse going on during the course of the interrogation. That, again, is critical to ensure that we're doing things right. The document that you got and received today was a statement by the Commissioner of Public Safety in detail outlining why she believed that it is imperative that we retain what we have right now about the use of targeted deception in interrogation. She describes it, if I may read from her comments, Mr. President.
Without objection, you may.
Targeted deception is a vital tool in serious criminal investigations, particularly for addressing child exploitation and sexual assaults. In the Vermont Supreme Court case, State versus Colts, targeted deception was used successfully to elicit a truthful admission to aggravated sexual assault of a child in Vermont, kind of thing that we've been trying to control for a long time. The Attorney General's office, also, I spoke personally to the Attorney General, and she is opposed to the underlying bill and is in favor of the kind of amendment that I have introduced today. Legal safeguards already exist, as the Commissioner of Public Safety says, to ensure voluntary admissions by suspects in Vermont, including the requirement for corroboration of confessions by independent evidence and the need for the prosecution to prove voluntariness prior to trial. S-285 overlooks the value of targeted deception, which is a constitutionally permissible technique upheld by the Vermont State Courts, U.S. Courts of Appeal for at least 3 circuits, and which protects communities from perpetrators of serious crimes. The Reid technique, which is prohibited by this, is based on the assumption that it is a discredited methodology. It is not. And I can produce a zillion pieces of evidence based on comments by people who use it today, including those in Vermont who use it, and the results they've achieved. And of all, this is a technique, as I mentioned, it's been around for a long time. John Reid created the beginnings of this technique in, I think it was 1957. And I was trained in the technique as an interviewer, an interrogator, and a polygraph examiner by Richard Arthur, who's also written on the subject, who was a former partner of John Reid. There are variants of this technique that exist right now. There are 4 or 5 or 6 methods. You eliminate one, it doesn't eliminate the remaining terms that are similar to, but not exactly the same as Reed report. See, my belief is that you're not actually accomplishing anything. There is a method, as I say, the British method, originally called the peace method. And it is a different kind of technique, but it also has in common the elements of treating the person who is being interviewed appropriately. Not yelling at them, not threatening them, not coercing them, and not promising them anything that you are unable to deliver. But at the end, it's still the issue of not relying solely on the confession. Confession gets you an end. It helps you understand what happened. But then from the information that you get in the confession, as well as other information that you have regarding the suspect's guilt, you still have the ability and the responsibility to go to the next step and determine the corroborating evidence that gives you an assurance that the confession that you got is real and the person hasn't been forced into making it. All of those things are essential. We just passed 120 yesterday. And that's a classic example of why this is needed, because we do have a problem. We have a bigger problem than we see in some cases on the surface, and that we have sexual assaults that are occurring on college campuses that are not being reported to the police, but that still are real and still require investigation. And when they do get reported, to ensure that the perpetrators are identified and stopped. The Colts case in Middlebury is a classic example in which we have an aggravated sexual assault on a child that may never have been resolved had it not been for that interrogation. And this happens over and over and over again. So I strongly recommend and ask the body to think carefully about this. This is a constitutionally protected type of interrogation. It is used very widely in the United States, and it is permitted both by the Supreme Court of the United States and by the Supreme Court of Vermont. Thank you, Mr. President.
Question is, Senator from Chittenden Central.
Thank you, Mr. President. I want to reiterate that the language in S285 around the model interrogation policy and its applicability to all people is the language that was passed last year in S6. The changes that were made to this language were to ask the LEAB to take the first pass at model policy so law enforcement can weigh in more, as opposed to in S6 where it was the Vermont Criminal Justice Council. They will now work to fine tune what the LEAB produces. This also adds in a check back with the Joint Justice Oversight Committee. The bill does ask in both Section 2 and Section 4 that the policy take under special consideration interrogation practices for those under 20, as well as those with developmental or psychiatric disabilities. And that for those populations, they need to develop interrogation practices in all instances. With respect to the Reed method, the International Police Association of Chiefs of Police and the UN have discredited this practice. Just because we have always done something doesn't mean that it is right. And I want to be very careful about invoking sexual assault survivors, as these very same practices have been used against them to get them to recant their stories. People who do not report sexual assault cite many reasons why they don't do so, one of which being that they do not trust the police. These interrogation practices will go to build trust and protect victims and all Vermonters. At one time, it was common mental health practice to force lobotomize people. Today, we would consider this barbaric because we know better. We have better evidence and we can do better to treat people. The same is true here. At one time, this was what we knew. And now we know that we can do better. We can protect victims without deception. And we can also protect the people that are being interrogated. Your Judiciary Committee found the amendment not favorable on a vote of 4-1-0 and asked the Senate to concur with us. Thank you.
Senator from Franklin.
Thank you, Mr. President. This entire issue has been before this body before. It was before us in S6 last year that I believe the senator referred to. I have a statement that was issued by a number of people and a number of individuals in response to S6 last year after the governor vetoed the bill. May I read a portion of that statement, Mr. President?
Without objection, you may.
This is a statement that was on June 16 of 23, providing an explanation as to why S6 is not ready to become law and the legislature should not override the governor's veto. It goes on to say that targeted deception is a tool used to elicit truthful reactions about the suspect's own culpability, helping to identify victims and stop perpetrators of sexual and physical violence. This bill, S6, does not support community and victim safety while taking away a tool to address child exploitation and sexual assaults. Goes on to say the commander of the Internet Crimes Against Children Task Force testified that the, quote, the removal of targeted deception will mean that victims previously unknown to law enforcement will not be identified and will therefore not receive the support, services, and interventions that they need. There has been no case that we're aware of in the history of Vermont in which a false confession has resulted in the conviction of anyone. And for this particular statement, let me add that this statement was signed by the Vermont Children's Advisory Centers, including the Caledonia Advisory Center, the Chittenden Children's Advisory Center, the Northwest Unit for Special Investigations, the Lamar County Special Investigations Unit, the Orange County Special Investigations Unit, the Orange County Child Advocacy Center, the Child First Advocacy Center and Rutland Unit for Special Investigations, Our House of Central Vermont, Inc. in Washington County, the Wyndham County Safe Place Special Investigation Unit, and the CACs of the Family Place in Windsor County. It was signed by the Executive Committee of the Department of States Attorneys and Sheriffs, including the state's attorneys of Rutland County, Windsor County, Bennington County, Orleans County, Grand Isle County, and Wyndham County. It was signed by John Campbell, the Executive Director of the Department of States Attorneys and Sheriffs, by Jennifer Pullman, the Executive Director of the Vermont Center for Crime Victim Services, by Benjamin Herrick, the President of the Vermont Police Association, by Ron Hogue, the President of the Vermont Association of Chiefs of Police, and by Sarah Roberts, the Victim Advocate Program Coordinator of the Department of States Attorneys and Sheriffs. And of course, we have here today the signature and support of this amendment and the rejection of the underlying bill by the Commissioner of Public Safety of the state of Vermont, and my personal conversations with and coordination with counsel for the Vermont Attorney General, who also is opposed to the underlying bill. Thank you, Mr. President.
Senator from Bennington.
Mr. President, I wonder how many people have ever heard of Paul Lawrence? Paul Lawrence was a police officer in several communities in Vermont, and over 100 convicted felons were released because of his false information provided. So to tell me that nothing like this ever happened in Vermont is troubling. Mr. President, your Judiciary Committee, and I admit I voted against the bill in committee for some of the reasons that the Senator from Franklin has mentioned. But I cannot sit here and listen to this about S6, which was vetoed by the governor. We did not hear from these groups until well after the bill had been voted out of this chamber. Now, why we didn't get the communication, I don't know. During the conference committee last year, your conferees worked hard, and there was a lot of angst about the House version of the bill. We turned it back to the Senate version of the bill and came away thinking we had done something well. Our testimony about the Reid method was always negative in our committee, hour upon hour upon hour over a 2-year period. To suggest that all these people support the Reid method is just false. And quite frankly, I'm surprised at much of what has happened here, but I cannot support a bill that doesn't that recognizes or an amendment that would delete the reference to the Reed method. So, Mr. President, again, I wasn't going to speak, but I'm just troubled by that list of people who opposed the bill last year. Didn't come to me or any other member of the conference committee or any member of the Senate until after we had voted and sent it to the governor. So it was a failure to communicate. I'm not sure who's to blame, but that was certainly a failure to communicate.
Senator from Franklin.
Thank you, Mr. President. I'd like to respond to the Paul Lawrence situation. For those of you who don't remember, Paul Lawrence was a detective with the St. Albans Police Department. He formerly been the chief of police of Virgins, and before that, he was a state trooper. I'm very familiar with Paul Lawrence because I did the Paul Lawrence investigation. If you pick up the book called Mocking Justice, which is a history of the Paul Lawrence investigation, I'm chapter 7. I did a lot of the work of the Paul Lawrence investigation to find that he was crooked, and did so. I was working at that time on contract for the Defender General's office. I conducted polygraph examinations and interrogations of more than 30 of the defendants. I did not find a single one of them lying, and that was my opinion. And then the report that I did afterwards showed a number of cases in which Paul Lawrence was lying. And Paul Lawrence was convicted of lying, in particular on some of the specific counts that I found during my investigation, including lying about the reasons why he left the military, which he falsified in testimony compared to what was on the record that I uncovered. And I interviewed scores of people, both inside and outside of government, including those defendants. And I add, not a single one of those defendants did I find deceptive. Not a single one of those defendants gave me a false confession or otherwise confession because they were innocent. We were able to establish that. And I used that variant of the Reed technique as I interviewed each and every one of them. That notion that the Reed technique is universally discredited is false. And the names of some of the people that I've described here who use that technique or who are familiar with that technique is evidence of that. The Commissioner of Public Safety also indicates that although the state police teach the peace method, there are people who do and still use the Reed technique or similar variants of their interrogations, and it is not prohibited by the state police. Thank you, Mr. President.
Senator from Chittenden Central.
Thank you. I did want to speak to some of the witnesses that were opposed to S6. The Windham County Special Investigations Unit Executive Director was opposed to S6 and was opposed to S285 as it was introduced. However, I did ask them on the record if they would support removing the outright ban and passing the model policy language applicable to all people. And they testified that they could support this. So some of the changes that were made in S285 took into account the objection to S6 and tried to find a moderated path forward. Thank you.
Question is, shall the report of the Committee on Judiciary be amended as offered by the Senator from Franklin County? Are you ready for the question?
Roll call.
Roll call has been requested. Was that the other Senator from Franklin who requested that or the proposer?
Yes, sir, Mr. President.
That's what I thought. Question is, shall the report of the Committee on Judiciary be amended as offered by the Senator from Franklin? Are you ready for the question? If so, the Secretary shall commence to call the roll.
Senator Baruch,
No.
Senator Bray,
No.
Senator Brock,
Yes.
Senator Campion,
No.
Senator Chittenden,
Yes.
Senator Clarkson,
No.
Senator Collmore,
Yes.
Senator Cummings,
Yes.
Senator Dooley,
No.
Senator Hardy,
No.
Senator Harrison,
No.
Senator Hashim,
No.
Senator Ingalls,
Yes.
Senator Kitchell,
No.
Senator Lyons.
Yes.
Senator McDonald,
No.
Senator Mazza, Senator McCormick,
No.
Senator Norris,
Yes.
Senator Pershing,
No.
Senator Ron Hinsdale,
No.
Senator Sears,
No.
Senator Scar,
Yes.
Senator Bihowski,
No.
Senator Watson,
No.
Senator Weeks,
Yes.
Senator Westman,
Yes.
Senator White,
No.
Senator Williams,
Yes.
Senator Renner,
No.
Senator Mazza,
Please listen to the results of your vote. Those voting yea, 11, those voting nay, 18, and you have failed to amend the report of the Committee on Judiciary. Question now is, shall the Senate adopt the report of the Committee on Judiciary? Are you ready for the question? Senator from Windsor.
Thank you, Mr. President. May I interrogate the presenter of the bill, please? Thank you, Mr. President. Would the reporter be kind enough to share with us what the vote in committee was? I don't think I heard it.
The vote in committee on S285 was 3-2-0.
320, thank you. I have a lot of concerns about this bill. I have concerns about the age. I have concerns about sexual and online deceptive practices where I think they may, with sexual assaults may be appropriate. I guess my question for the reporter at the moment is, how do we distinguish between deceptive interrogation, custodial interrogation, and deceptive investigations? Because investigations, I think, are quite different. And I would just like to know what this bill addresses. It addresses, as far as I can see, only interrogations.
Thank you. Yes, you are right. There is a significant difference between an investigation and an interrogation. We had lengthy committee discussion about this and a lot of different sort of ways of examples of things being put forward. And this bill does look to address interrogations, not investigations. One example that came up in committee is if I'm in a chat room or a law enforcement agency is in a chat room and is pretending to perhaps be a 13-year-old girl, that is not prohibited under this bill. If that person is brought into custody and the person is told, we know you were talking to a 13-year-old, that would be prohibited. However, that person could still ask, did you think you were talking to 13-year-old girls on the internet? And that would be perfectly fine. So in some of the instances we have been given, there is a simple reframe to the question that allows you to get at the same information without crossing the border of deception.
I appreciate that distinction because I think that the deceptive interrogation investigations are critically important to some of the work that we do. As you all may recall, last week, a World War II team was given a very special medal for their deceptive practices during the course of World War II and how they thwarted several initiatives of the Nazis through their incredible deception and theatrical misrepresentations. And it was interesting to hear about that and was reminding me how important deception, how constructively deception can be used in the course of investigations and in the course of some of our public safety work. So I appreciate that distinction. And I think in that capacity, am more supportive of this bill, which has been a challenge for me. Thank you very much.
Senator from Chittenden Central.
Thank you, Mr. President. I appreciate the remarks from my colleague from Windsor. I don't know if I would use what we did or didn't do to the Nazis as a point of comparison for what we should do in custodial interrogation. With that said, I would just like to take a look at the phrase tool in the toolbox, because we heard it many, many times in committee. And it jogged my memory. The other time when we heard it many, many times was when the committee moved to prohibit the chokehold post-murder of George Floyd. If you remember that moment, it was a kind of shattering moment in American history. And we considered a bill in the Judiciary Committee to prohibit the chokehold. And I heard again and again from the Department of Public Safety and others in law enforcement how valuable a compliance tool the chokehold was. And that struck me very, very forcibly, as it did the rest of the committee, and this body, as well as the House, moved to prohibit the use of the chokehold. The only time the chokehold is now allowed is if lethal force is otherwise indicated. So if you can use a gun to kill someone as a last resort to save your life as a law enforcement officer, you can then use the chokehold, but in any other circumstance, it is prohibited. And that was because we disagreed as a legislature that it should be in the toolbox. So the fact that DPS or anyone says that deception is a tool in the toolbox, I no longer am moved by that phrase. So what I would say is, for me, the question came down to, should this be banned for everyone or should it be banned for children? Those under the age of majority. And in my thinking about it, I originally was of the opinion that we could satisfy our consciences by limiting it in the case of minors. But the more I thought about it, and frankly, the more I listened to my colleague from Chittenden Central, the more I began to wonder why we were so protective as an institution of the tool in the toolbox that is deception. Nobody even moved to create a different word for it. Everybody just kept, as we have today, everybody kept referring to it as deception. So yes, we are going to deceive people because it's a valuable tool in putting them in jail. Should it be? The more I thought about the should it be, the closer I got to voting for the underlying bill. And that's where I am today. That's where the UK is. That's where in many places in the international community, they are. And so my question is, for myself and for others, should it be allowed that when people are taken into custody, they are rightfully afraid for their liberty, for their life, and they are in custody with the police? Should we greenlight as a standard tool in the toolbox that they can be lied to? And I would say as forcefully as I can, I now believe the answer is no. That's why I voted for the underlying bill. That's why I will vote for the underlying bill today. Thank you, Mr. President.
Just as a point of clarity, there is an underlying bill. There's actually a Judiciary Committee report to that underlying bill. So I don't know if that's entirely clear to everybody. Senator, you wish to clarify, or if people understand what was meant?
I think people know where I'm coming from.
Just want to make sure. The question is, shall the Senate adopt a report of the Committee on Judiciary? Are you ready for the question? Senator from Franklin.
May I interrogate the reporter, Bill, Mr. President?
Senator from Chittenden Central is interrogated.
On the issue of interrogation, as we look at section 2 of the underlying bill, the subsections of that bill refer to such custodial interrogations occurring in a place of detention, custodial interrogations occurring outside a place of detention, and those are defined clearly in statute. What is an interrogation that is not considered custodial regardless of location? Does it have a name, and does it follow the same as rules as elsewhere?
I would have to check in with legislative counsel to definitively answer that. So if we can take a small recess, I'd be happy to do that.
Chair will declare a short recess till the fall of the gavel.
Thank you, and I want to
The Senate will please come to order.
Thank you. And I want to thank Legislative Council for helping me remember the lengthy discussion on this. So the way that this is written is a little clunky. The outright ban on deception only applies to custodial interrogations. However, we also tasked the Criminal Justice Council to develop model policy for these other types of deception. We give them the discretion for those under 20 to decide if there may be, in some instances, additional bans on deception for that population in interrogations that are not custodial. So it's very clunky, but the prohibition is only applicable to custodial interrogations. The policy, the larger interrogation policy, would apply to other interrogation policies.
Senator Franklin, you've had the floor, so thank you for staying. Are you finished?
Yes, Mr. President, I would thank the reporter. I would just add that I heard the opinion given by counsel and can only comment that counsel and other parts of state government have a different opinion. Thank you, Mr. President.
The question is, shall the Senate adopt the report of the Committee on Judiciary?
Roll call.
Roll call has been requested by the Senator from Chittenden Central. The question is, shall the Senate adopt the report of the Committee on Judiciary? Are you ready for the question? If so, the Secretary shall commence to call the roll.
Senator Baru,
Yes.
Senator Bray,
Yes.
Senator Brock,
No.
Senator Campion.
Yes.
Senator Chittenden,
No.
Senator Clarkson,
Yes.
Senator Collmore,
No.
Senator Cummings,
No.
Senator Yulee,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashi,
Yes.
Senator Ingalls,
Go.
Senator Kitchen,
Yes.
Senator Lyons.
Yes.
Senator McDonald.
Yes.
Senator Mazza, Senator McCormack,
No.
Senator Norris,
No.
Senator Pershling,
Yes.
Senator Ron Hinsdale,
Yes.
Senator Sears,
No.
Senator Starr,
No.
Senator Bihowski,
Yes.
Senator Watson.
Yes.
Senator Weeks,
No.
Senator Westman,
No.
Senator White,
Yes.
Senator Williams,
No.
Senator Renner, Senator Mazza, Senator Renner,
Please listen to the results of your vote. Those voting yea, 16, those voting nay, 12, and you have adopted the report of the Committee on Judiciary. Question now is, shall the bill, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you have ordered third reading of S 285. We now have up for consideration S 159. S 159 is read for the first time and referred to Committee on Government Operations, which considered the same and recommends that when the bill is amended, the bill ought to pass. The bill was then referred to Committee on Appropriations, which also agreed that when the bill is amended, the bill ought to pass. Please listen to the second reading of the bill.
S 159, an act relating to the County Governance Study Committee.
Now you've heard the second reading of the bill for the report of the Committee of Government Operations, Senator from Addison.
Thank you, Mr. President. Changing gears a little bit, everybody take a big, deep breath. This is something different. And I don't usually get excited about studies, but as any member of the Senate Government Operations will tell you, I'm excited about this study. I'm kind of a nerd about it. A senator from Windsor over there is laughing at me. I can see it. But this is a study. That's all this is a study on county and regional governance. And why do we think we need to study this? As many of us have heard over the last several years, when we're talking about our municipalities, especially in really rural parts of the state, where there's a lot of small towns, like in many parts of my district and many parts of almost everybody's districts, we are seeing a capacity issue with our municipal governments. There is an increasing need around the state for services, whether they be public safety services, property appraisal services, elections administration services, school facilities services, federal funding and grants administration services, emergency management services and emergency communication services. There are all types of services that are right now often the responsibility of our small municipal governments. And how many of us know that every little tiny town has to deal with whether they have a fire truck and whether they have a snow plow and whether they have somebody who can answer the phone at the clerk's office when somebody needs to come in and get a birth certificate or whatever it is. So there are lots of services that our little towns are required to do, and they are feeling stressed and they are feeling like they have capacity issues. And your Senate Government Operations Committee heard this time and time again last year when we were dealing with all sorts of bills. We do have county government in the state of Vermont, and we talked about county government quite a bit last year, but our county government is very weak. It is not very well established in our state, and we are one of the few states in the country that it doesn't have well established county government. So we asked the question, what would it look like, or what could we do differently if we had stronger county or regional government? We have in this body created a bunch of different regional governments. We've created over the last few years solid waste districts and communication union districts and regional planning districts and lots of districts that don't quite overlap very well. And sometimes our towns fall through the cracks. They might be part of multiple districts. Just the other senator from Addison and I know well that the town of Huntington that falls through a lot of cracks because it kind of is in the little like triangle between a lot of districts. So we just wanted to talk about what could happen if we looked at strengthening or coordinating county or regional government. So we this bill would create a county and regional governance study committee to address local government capacity challenges, enhance and optimize public safety, regional collaboration and planning, efficient, equitable, and transparent public resource allocation, and effective regional public services for individuals and municipalities. That's what the statement of the creation of this committee would do. You can find this on page 1635. The study committee itself is made up of 6 legislators, 3 from each body, and in order to ease the work of our legislative staff, we kept it small and focused just on legislators, but created what we're calling a technical advisory group. And the technical advisory group would include all of the members of people in regional and county government. So on 1637, you can find the Department of State's Attorneys and Sheriffs, the county state court administrator, the Association of County Judges, the Association of Planning and Development Agencies, Municipal Clerks and Treasurers Association, Vermont League of Cities and Towns, the Regional Development Corporation, School Boards Association, Vermont Town and City Management Association, and other relevant stakeholders would be part of a technical advisory group that would be facilitated by the Vermont Bond Bank. We had all of these entities in. They are all supportive of this concept and all supportive of the work of the study committee and the technical advisory group. And the committee would look at the enhancement and optimization of public safety, enhancement of regional collaboration and planning, efficient, equitable, and transparent allocation of public resources, promotion of effective regional public services for individuals and municipalities, clarification of the role and oversight of elected county officials and their departments, reduction of duplicated public services and promotion of opportunities for intermunicipal collaboration, balance of availability and cost of services across municipalities in each county, mechanisms of county and regional government structures in other states, and the impact of climate change and resiliency on the maintenance of public infrastructure, delivery of regional government services, and coordination of regional emergency planning. This last one came to our attention quite frequently this session as we were dealing with the government response to flooding bill, which we will hopefully hear on the floor tomorrow. So that's what this bill does. It creates a study committee made up of legislators with a technical advisory group. The report would be a report back to this, to the legislature in November of 2025. So it would be a lengthier study. And in my mind, because as you know, I love libraries so much, it was very similar to the status of libraries report that resulted in the library bill that we voted on earlier today. So really just taking a longer look at all the complexities of county government. There is a provision in section 3 on page 1638 that honored before September 15th, the Secretary of Administration or designee shall report to the governance committee, the study committee, on federal funding opportunities resulting from disaster declaration for the major flooding events of 2023. In working with the administration and the chief recovery officer, there is a strong hope and a strong possibility of receiving a federal grant in the wake of our flood recovery that could actually help pay for some of this work and maybe even resulting in being able to do a lengthier, more in-depth study with an outside consultant or entity like University of Vermont or Norwich University or the National Association of County Governments or some other entity that could do a lot more of the in-depth work with this federal grant. The original bill did include funding as a match and to help support the county government study, but we'll hear from the Appropriations Committee on that. I do want to reiterate that I can read the list of witnesses, but it's basically everybody who was on the technical advisory group plus the administration, and we did hear from county government officials at the national and level, and also the state of Connecticut, which is one of the few states that doesn't have any county government. They have a council of state governments they council of regional governments, and we heard from them as well about their model. So again, Mr. President, this is just a study, but I think it's a very exciting study and could lead to more efficient and effective government at the regional level, taking some pressure off our municipalities and at the state level. So thank you very much. Oh, wait, I'm sorry. The vote in committee was 6-0-0, and we ask for your support. Thank you.
Bill is then referred to Committee on Appropriations for the report of the Committee on Appropriations, Senator from Bennington.
President, I would say that the Senate Appropriations Committee wasn't as exuberant as Senator from Addison, but we did kindly look upon the bill. And we found that the cost of section G, which is the meetings and the reimbursement, to be extremely small. So we approve that. However, in H on page 1637 of today's calendar, your Committee on Appropriations recommends that we strike section 8 to $50,000 and that it be part of our consideration when we do the budget in a few weeks. So with that, Mr. President, the vote in the Appropriations Committee was 6-1-0.
So the question is, shall the report of the Committee on Government Operations be amended as offered by the Committee on Appropriations? Are you ready for the question? Senator from Rutland.
Thank you, Mr. President. May I interrogate the reporter of the bill? Of the base bill?
You could, however, the vote at the moment has to do with the appropriations amendment. So if it's related, all right, then. The question is, shall the report of the Committee on Government Operations be amended as offered by the Committee on Appropriations? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have amended the report of the Committee on Government Operations as offered by the Committee on Appropriations. The question now is, shall the bill be amended as offered by the Committee on Government Operations as amended? Senator from Rutland.
Thank you, Mr. President. Might this be the appropriate time?
It would
to
be.
address the report and Interrogate the report.
It is. The Senator from Madison.
Thank you, Mr. President. So worthy report. I understand what the committee and the chairman are advocating. I'm just curious if a section of the report will outline, Mr. President, the notional cost for all the lists of potential enhancements which could be created by the study group. If that will be an element of the report, or if notional costs would not be part of the report.
Thank you, Mr. President. Could you state what you mean by notional costs? I just want to make sure I'm answering correctly.
So for example, thank you, Mr. President. Enhanced, so page 1635 on the bottom, paragraph A, enhancement and optimization of public safety. I'm sure all of the organizations involved would have thoughts and recommendations on how to enhance and optimize public safety. Once that list is congealed into the report, if there will be an accompanying cost associated with those enhancements.
Yes, thank you for that clarification. Yes, embedded in the report would be information about the costs, including the efficient, equitable, and transparent allocation of services, and then also the reduction in duplicated services and the availability and cost of services across municipalities. So inherent in the report would be considerations of costs, whether they be cheaper to more costly or less costly to provide in a different way across regions of the state. So that is supposed to be part of the report.
Very good. Thank you, Mr. President. I thank the reporter.
Question is, shall the bill be amended as offered by the Committee on Government Operations as amended? Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it, and you have adopted the amended report of the Committee on Government Operations. The question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes appear to have it. The ayes do have it, and you have ordered third reading of S-159. Senator from Chittenden Central.
Thank you, Mr. President. Again, we are exactly at our declared adjournment time. So thank you to everyone for an efficient and orderly discussion. With that said, pending announcements, I would move that the Senate stand in adjournment until 1 p.m. Thursday, March 28th.
Are there, Senator from Bennington?
President, I move that the rules be suspended for the purpose of moving a bill from the Judiciary Committee to the Agriculture Committee, H614, and act relating to timber trespass.
Now, the Senator from Bennington has moved that the Judiciary Committee be relieved of H614, and, excuse me, the Senate suspend its rules in order that, actually, it's not a suspension of rules, excuse me, that the Senate Committee on Judiciary be relieved of H614, an act relating to land improvement, fraud, and timber trespass, and that the bill be referred to Committee on Agriculture. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have relieved the Committee on Judiciary of H614 and referred the bill to the Committee on Agriculture. Are there any other announcements? Senator from Washington.
Thank you, Mr. President. Senate Finance will meet 10 minutes after the follow-up.
Senator from Bennington.
Thank you, Mr. President. Senate Education will meet at 3 o'clock.
Senator from Madison.
Senate Government Operations will also meet at 3 o'clock.
Senator from Essex.
Thank you, Mr. President. Senate institutions will meet at 3 o'clock.
Senator from Addison.
President, tomorrow morning, Senate Natural Resources will meet at 9 a.m.
Senator from Windsor.
Thank you, Mr. President. Tonight's Farmers Night is going to be terrific. And it's either going to be in the house or it'll be in the cafeteria, sadly, because I think the house is going to have a very long session. But tonight we're going to have two of our finest musicians in this neck of the woods, Becky Tracy and Keith Murphy. Becky is an incredible fiddler with a tradition from Quebec and Ireland and a really rich dance tradition of dance music. And Keith plays a lot of different instruments and sings beautifully. And he's from Newfoundland, and he carries with him this great French-Canadian tradition of music. So I encourage you to come for an hour of what's going to be fabulous music.
Are there any other announcements? By way of announcement, I would agree with the senator from Windsor, having heard both of those musicians. They are truly spectacular. But my primary reason of speaking is two brief sort of procedural protocol updates to help alleviate any confusion. The first is just a reminder that when interrogating another senator, when one has concluded those questions and interrogations, please make it clear to the person being interrogated that you are finished. That has not always been happening, and at times folks have stood during then the sort of closing argument of the original speaker. That would just be a courtesy to try to remember. The second is if one has an amendment in the calendar, it actually does not mean that you are automatically recognized to offer that amendment. In fact, you may choose not to. And there's not a need for us to recognize someone to then choose not to offer an amendment. It actually is done differently in the journal as well with respect to how it is journalized. So when the question is asked about the circumstances prior to that amendment, that is when you would rise on your own to be recognized to offer the amendment. If you do not rise, the amendment will appear in the calendar, but it will not be offered if we move on to the vote without that happening. So just want to let people know that. With that, the senator from Chittenden Central has moved that the Senate stand adjournment until Thursday, March 28th at 1 p.m. Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have adjourned until Thursday, March 28th at 1 p.m.